All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
All right, thanks, guys. So I want to briefly touch on a couple of topics today. The first is a little bit of a nod to Bert's West Coast tour, and it's one that we've been dealing with a lot in my practice area so far in 2024, and that's the pair of new California non-compete laws. And you may be wondering, hey, I thought California already banned non-competes a long time ago. What more could they possibly say or do on this subject? And apparently the answer is quite a lot more. Yes, non-competes have been banned and unenforceable in California for a long time, but California was concerned that out-of-state employers are continuing to try to enforce non-competes for employees in the state, such as where an employee moves into California with an existing non-compete and then tries to get a job in California. So the first new statute bars non-competes involving a California resident as being void and unenforceable, regardless of where the contract was signed or when it was signed. So if they signed it in Missouri and they move into California to take another job, it's unenforceable. And this gives.
So let me stop you there, Justin. Make sure I'm understanding this. So I lived and work in any state other than California. And now I exited the company. We entered into a non-compete that was completely legal and binding in the state in which I lived and worked. And now I moved to California for some reason. And at that point, that non-compete, now that I'm a resident of California, even though I never worked for that previous company while I was a resident of California, is no longer binding.
That's correct. That is what the law is intended to do. And as you can probably imagine, this will give rise to a whole bunch of thorny choice of law issues. What we're expecting is that employers in the more non-compete friendly states will end up trying to make a race to the courthouse to try to get the case started somewhere other than California. You know, a judge in Texas or Indiana or South Carolina may say, well, you know, that's nice for California that they've passed this law, but you know, we have our own set of choice of law principles. And one of the most important questions in that analysis is, where was the contract executed? Where was it to be performed? And they may not view the California law as trumping their own state choice of law principles. Now, on the other hand, you may have employees move to California and then file an action to try to beat the employer to the punch. And we have seen this. I heard about a situation, employee moved right before the new year, right before the law took effect, and was in a state where the non-compete would have been enforceable, moved to California and then filed an action saying, hey, this is no longer enforceable and you can't hold me to it. So we're going to see a lot of interesting issues on that point. I think there will be some interesting case law from various states, and it'll be interesting to see how they treat that California statute. And what's important here is it gives rise to liability. It gives rise to the ability to file a civil action for injunctive relief, for damages and attorney's fees. So there is a risk of trying to enforce that statute or that agreement as to an employee who now lives in California.
So in addition, are employers expected at that point to find these individuals to know if they've moved? So for an example, if I've entered into an agreement, 6 months ago and I've lost touch with this employee, I have no idea where they live. Do I have a responsibility to do anything at this point?
Well, that's a really good question, Phil, and it'll even be more relevant to the next statute I'm going to talk about, this notice statute. But yes, I mean, I think if it's important to keep tabs on where they're at, and if they've moved to California and you know that, it's going to be important to either file a lawsuit in your own state, or maybe you decide it's just not worth it at that point, and enforcement isn't the route you decide to go. In addition to this law as to employees moving into California, there's also a new California non-compete statute that requires the employer to give notice to their employees that any existing non-compete is void. No longer than February 14th, so just a couple of weeks from now, the employer must give a written individualized communication to anyone employed after January 1 of 2022. So it captures potentially some former employees. Anyone who had a non-compete, you need to let them know that it's void and won't be enforced. And our California attorneys are telling us that the statute is likely broad enough to cover employee and customer non-solicitation clauses as well. So don't just assume that because you don't use strict non-competes that you're in compliance. Depending on the language of your other restrictive covenants, you may also have an obligation to give notice and may need to rescind those types of clauses. What's important here is that the notice must be individualized. You can't just have a blanket statement like, if you have a non-compete, we won't enforce it anymore. It's going to require the employer to be specific about the provision at issue. Paragraph 5 of your June 10, 2021 employment agreement is void and enforceable, and not just a blanket, we're not going to enforce anything. And obviously that's a challenge for some employers. If you have a lot of impacted employees, or you aren't sure whether or not they have a non-compete, that could be challenging to comply. Our colleagues out in California have been dealing with this issue quite a bit over the last few weeks. They've put together some useful resources, including a template notice letter for employers to use. But if you're an employer and you think this might apply to you, you have about 2 weeks to work on compliance. And failure to comply, according to the statute, is an act of unfair competition. So there is a risk of liability for not complying. So Phil, with all the legislative and FTC activity around the country on non-competes, it seems that California just couldn't help themselves and decided they wanted to join the fray as well.
Yeah, that's a lot of undertaking, but hopefully in today's world, we don't have too many of those going on. I do know it is a common and customary practice for many of our employers, but hopefully we haven't had that much separation. But this could be even the case. What I'm hearing you say is, like, if employees have signed these and quit on their own, it isn't necessarily all under termination, right? It's that confidentiality, non-compete element that we signed and I resigned. I'm still bound by that in most minds. But if I'm in California now, there's a different game here. So do I need to go back and look at anyone who had signed these and separated for any reason is probably the right practice to have?
Yes, and the cutoff date for that is January 1 of 2022. So if someone is employed during that window, they are going to be covered by the notice requirement. And we're telling employers you need to use reasonable due diligence to find your former employees. Obviously, if they've gone completely off the grid, you may not be able to locate them. You're not going to be able to comply with it in that instance. But if it's something where their last known address, or somebody in the company still knows where to find them, we're telling people you need to use your reasonable due diligence to give them notice.
If Bert was here, he would say, if they're in California, they are completely off the grid. I mean, only someone completely off the grid would go there. All right. Anything else, Justin, that you have for us today?
Yeah, I just wanted to briefly touch on the Pump Act and some recent guidance from the Department of Labor with respect to the retail and restaurant industries. As a quick refresher, the Pump Act was passed in 2022, and the remedies provisions of that took effect in April of last year. It requires employers, with some exceptions, to provide reasonable break time in a private space for nursing mothers to express breast milk in the workplace. Now, if you're an employer in an office setting, this probably wasn't very difficult to comply with. You just convert an unused office or a closet into a suitable space. But for some employers, this has been a particular challenge, either due to the physical constraints of the workplace or the nature of the business. And one industry that it's been a challenge for is retail and restaurants. Oftentimes there's not a great private space for expressing, and because of the unpredictable way that customers ebb and flow throughout the day, it can be a challenge to allow an employee to step away at a moment's notice. So the DOL issued some guidance in the form of a webinar and some presentation slides that gives some industry-specific guidance. And I would say the big takeaway is to remember that the Pump Act does not require a permanent space. It could be a closet, it could be a manager's office. The key is ensuring that the space is suitable, it's readily available when it's needed, and you need to make sure that it's private. So surveillance cameras turned off, posted signage letting employees know that the area is off use. So Phil, if I were to summarize the DOL's view on this, it's figure out a workable solution as best as you can with the resources and the space that you've got. It's going to differ from employer to employer, but it may require getting creative. And, I also want to note that the DOL is planning to issue some more industry-specific guidance and suggestions on the Pump Act in the next few weeks, including in the transportation industry and educational services sector. So if you're an employer in an industry that has struggled with how to best implement this, stay tuned for more guidance on this.
Yeah, no, this one I can see I can see the complication, particularly like you said, in those industries that are outside your traditional office setting. I think construction type industry, field positions where I'm out, you know, like you say, transportation, restaurants, those types of things, it becomes quite difficult to comply. So creativity will be needed